You're in a situation where a contract is about to be established between yourself and another party, and you're looking for ways to manage your risks. Now, one way of doing that is through alleviating certain responsibilities that you would have incurred in a natural circumstances. And that's what exception clauses is about. So in this video, we're talking about exemption clauses and how they operate. Of course, exemption clauses are contractual terms, so they'd be terms that two parties would have agreed on including as a specific enforceable condition or a provision in the contract. What it does is that it enables the party to protect itself, specifically if a breach were to occur by a party. So, for example, if I'm about to enter into a contract with someone else to construct their house, I can have an exemption clause to protect me from certain liabilities that I would incur. So I'd specify as a term that I won't be responsible for a certain damage if it were to occur. And that's an example of an exemption clause. Um, in terms of contracts, they're very common in commercial contracts, and of course, we're talking about the construction industry, which is um, which is a commercial field. So you find it in a lot of contracts. Most contracts nowadays, they do have exemption clauses, specifically when you're talking about the construction industry. And the reason for that is because construction is a very risky industry. So there's a lot of uncertain events that you're not sure of. And that's why exemption clauses can be used as a form of risk management. So it's managing uncertain events through maybe passing on the liability to someone else, particularly the party that's accepting the exemption over here. So now that we understand what exemption clauses are, when would exemption clauses be used? And as I mentioned, it's to exclude the right. So it protects, say for instance, if it's me that has the exemption clause specified in my contract, then I'm excluding the right of the other party. So they had a right, and I'm protecting myself by removing that liability. So the other party is given up that right if they do agree on the exemption clause. In certain cases, the exemption clause, they limit a right, so they don't cancel it. You don't exclude the right of the other party, but you limit the right. An example of that would be the time bar provisions. So a time bar provision is basically where a claim of right by the other party must be submitted or must be made to me, for instance, within a certain period of time. So I do specify that their claim has to be made within a certain period of time for it to be included. Otherwise, if they make it outside of that time period that's specified, then the right no longer exists, and that's a time bar provision. And the third example is where the the right is limited. An example of that would be where you cap damages. So if you know that there would be damages, you'd say, I won't pay more than $100,000, and that could be an exemption clause that's specified in the contract. Now, how do they operate in contract law? For an exemption clause to be effective, you need to give sufficient notice to the party whose rights will be impacted by the exemption clause. So that party that will either have its rights excluded or have its rights limited, they have to have been given sufficient notice. A sufficient notice over here is defined as actual notice. So an example of an actual notice would be where the party signs the contract, and it would be assumed that the party already has actual notice. Now, this case that you see in front of you, it's an English case, Old English case, and it's authority to the fact that if you have a term, an exclusion term, in a signed contract, so if you do sign on the contract and that exclusion uh, clause is included in the contract, then you are assumed that you have already accepted that term once you sign it. Even if you say or claim that you haven't read it, you would still have to abide by that exclusion clause. So you can't use the excuse that you didn't see the term or it was in fine print. If you'd signed the contract, if it was on the contract and you signed it, then you have to stick to that exemption clause. When is an exemption clause not operative? So when can you not rely on an exemption clause? In the cases where there is misrepresentation, the court can deem the exemption clause as non-operative. And the case over here that's authority to this, I can explain it in terminology that suits the construction industry because this is in a different industry. But of course, given that it's common law, same principles would apply. So in the construction industry, let's say, for example, that you asked me to perform the plumbing works in your kitchen or in your bathroom. And in the contract, I specified as an exclusion clause to protect myself that in the case that, because I have to rip off certain tiles to install plumbing pipes, etc. So in the contract, I specify that as an exclusion clause, if in the process of ripping off the tiles, I damage, certain parts of the wall, then I won't be held liable. And you accepted that. And then when I start working, I damage your sink, let's say. So, and you came and you claim for damages. Well, in this case, the exemption clause will not operate to protect me, and the right of the other individual will still be protected because this is misrepresentation from my side. I said that the clause applies to the wall. I'll try to protect the wall, but if I do damage the wall, then I won't be liable. However, I damage another item. And I'm misrepresenting over here because I'm claiming that I have an exemption clause and it covers everything, but it doesn't actually cover because I said that it's just for this wall. So that's just an example. And the same facts were present in this case, but in a different industry outside of construction. The other the other reason where an exemption clause wouldn't be operative is where it did not reasonably appear to the party whose rights will be exempted that the document is contractual. Now, this authority case over here, again, what it demonstrates is, and the fact in this case where there was some sort of delivery that was arranged via an oral contract, and then at the end of the delivery, a receipt was presented to the receiving party, and they signed the receipt. The party was asked to sign the receipt to, and in the receipt there was a fine print that said the party that delivered the materials will not be liable for any damage of the products that have been delivered. And it was found in the court that this exemption clause doesn't apply because it's not a contractual document. So the receipt wasn't considered as a contractual document. And again, another reason why an exemption clause would not operate is if the exemption clause was included in an unsigned document, and hence no constructive notice was given to the party whose rights will be impacted. And an authority case is this one over here. Now, notice that I said constructive notice. In the previous slide, we talked about actual notice. Constructive notice, as defined by the courts, is the party that's making the exemption clause, that's relying on it. They should have done whatever is reasonable to allow the other party whose rights will be impacted by the exemption clause to realize that this notice exists. Okay, so that's what constructive notice means. And this case over here, so if I were to simplify the facts and apply it to a construction industry example, for instance, let's say there was a construction site and a car park next to the construction site. Now you operate the car park, and let's say I'm driving through, and before I enter the car park, there's a ticket that I have to obtain, and then a boom opens up and I can drive into the car park. Now, what you did was you included an exemption clause on the ticket. It was in fine print, and it said that you won't be liable if the car is damaged because of the nearby construction site. That exemption clause in the ticket wouldn't apply as determined by this case over here. And the reason that it wouldn't apply is because there was no constructive notice that was given by your end to me. So you haven't done everything that's reasonable for me to notice that there was this exemption clause. That's an example of constructive notice.